Hello and welcome to Legalese. My name is Vincent Perryman and I'm a local attorney with the law offices of Vincent Perryman. Each month, Legalese focuses on a wide range of legal issues and topics. Today's show covers class action lawsuits. With us now is Malcolm Futhey, an attorney with Ferris Babango. Malcolm, thanks for being with us.
Thanks for having me, Vince.
We always hear about class action lawsuits and everybody's aware of these things. But I don't think anybody actually understands what they are or how they come to be.
Yeah.
So.
Well, a class action lawsuit, it's a civil action. It's not a criminal action, but it's a civil action in which you have one representative party representing a large group of individuals. So an example of a class action would be the latest MCI litigation, in which there was an early termination fee that they were charging their customers of cell phones. And there's a large class action that was settled, I believe, last year, in which they paid about $21 million in settlement to a big class of individuals who were customers of MCI, who were represented by one representative party in the class action lawsuit. So that's basically what a class action is.
So it's similar to any other civil litigation, just that all of the claims are so similar that you just have to have that one claim adjudicated.
Basically, it does follow generally the standard civil action procedure, but there's one big exception. There's Rule 23 in the federal courts, which kind of outlines how a civil action or a class action is filed. To file a class action, what you need is a lead plaintiff, a representative plaintiff who will represent the class, the group. And whenever a counsel will represent that plaintiff, the counsel will file a complaint asking that it be certified as a class action. Now, to actually have a class action, you have to meet 4 requirements preliminarily. You have to have numerosity, you have to have commonality of fact or law, and then you have to have a lead plaintiff who is an adequate representative of the class. In addition to that, the lead plaintiff needs to have a claim typical of the class. So going to numerosity first, you have to have so many people in a class to qualify as a class. Typically, at least 20 to 40 for there to be a question of whether certification can occur. And then if you have over 40 class members, typically you have enough to suffice as a class. And then the next big question that we spoke of, commonality, that's the next problem. You have to show that there are either facts or law that are common among all the class members. So a common fact scenario would be where you have some type of toxic spill. You have the common set of facts that affect everyone. You can have a common type of damage that everyone suffered. And in that same toxic spill example, you would have a common question of law as to how whoever made the spill should be liable to everyone who's affected. So those are the 2 main issues that you address generally. And then the 2 last concerning adequacy of representation and typicality refer to the lead plaintiff, just whether the lead plaintiff is suitable to represent the class. So you jump through those preliminary requirements, and then you go to the next step of just determining what type of class it is, type of class action. You have a class action in which you're seeing some type of injunctive or declaratory relief, and that's where you want the court to say that a particular defendant should stop doing a particular action. But most commonly what you see are these class actions called 23B3 class actions that concern a common issue of law or fact that predominate over all other issues. And then they're also the other additional requirement is that type of class action would have to be superior to bringing individual actions by each class member. And that's typically where you see the MCI class action that we just mentioned. That's the type of class actions that you hear about, the tobacco litigation, the asbestos class action. Those are all 23B3 class actions that are where you hear about the big awards for classes and attorneys' counsel.
So, because I've always had the impression that class actions were these big national pieces of litigation, and I'm guessing from what you just said, there's actually some smaller class actions. How does that work exactly?
Yeah, there are. Depending on what type of class action, you could have a company who's only affected people within a given neighborhood. For instance, if you have a toxic leak and you have to evacuate the neighborhood, well then you could have a class of the neighborhood, and then it'd be limited to that. It wouldn't necessarily be national, but you could still have 200 to 300 people affected who were evacuated from the neighborhood, and that could still constitute a class. On the other hand, you can have a company that has such wide sweeping effects from their actions that it does necessitate a national class action, such as Verizon, the Verizon class action that we spoke of. But and even then, and there are different types of class actions. Those are the typical class actions that you hear about. They probably take up a majority of the class actions. But you also have, for example, where someone has a question of riparian rights. Somebody upstream may want to know what rights he has to certain water from a river. And to do that, he could bring a class action against the individuals downstream. So in that situation, it's not where he's seeking monetary damages, but he's looking for the rule as to how he should act as to everyone. So
I guess in general, since the sizes can vary, I mean, can you have a class that's just 5, 10 people, or? Typically
not. Typically 20 is the minimum for a court to consider a class action. Now, you do have an example. There's a recent example that we talked about earlier where there was an attorney in Broward County who is undergoing disciplinary sanctions right now, and he managed to orchestrate a class action with only 7 people. He got a $7 million award and $2 million in attorney's fees. Of course, that doesn't fly. That was uncovered. It was thrown out by the Court of Appeals for fraud, and now he's facing sanctions. So, but typically you need at least 20. But to have a plausible chance for an attorney to really take up a matter as a class action, I would expect at least 40 or 50.
Okay. When we return, we will continue our discussion about class action lawsuits. Please stay with us.